State versus, is it Essad? Okay, will be the first case we're hearing today, and each side will have 15 minutes, and the appellant may reserve up to 5. Oh, I'm sorry, I just automatically did.
I understand, Your Honor.
They're looking at me like, why are you talking to me?
May it please the court, my name is Natasha Guerrero, and I represent the appellant, the state of Ohio in this matter, and I would reserve 3 minutes for rebuttal.
Thank you.
This matter stems from the trial court's granting a motion to suppress, and the state asserts that that was an error for 2 reasons. First, that the trial court's finding of facts were not supported by credible evidence, and secondly, because the trial court erroneously found that Sergeant Laughlin did not have reasonable articulable suspicion to stop the vehicle in this matter. Both of the appellees were charged with trafficking in drugs, felony of the 2nd degree, and possession of drugs, a felony of the 2nd degree. They filed a joint motion to suppress, arguing that the officers did not have reasonable articulable suspicion to stop the suspect vehicle, and also lacked reasonable articulable suspicion to extend the stop and allow for the canine sniff of the vehicle. The facts are that Trooper Trader and Sergeant Laughlin were on the Ohio Turnpike in a crossover, stationary, facing eastbound traffic. Trooper Trader was to the left of Sergeant Laughlin's vehicle. They were both in separate vehicles. Sergeant Laughlin observed a white truck that he noticed had a rapid reduction in speed. That caught his attention, and as it passed by both of them in the stationary position, they both observed some behaviors by the occupants in the vehicle. And after the car passed in front of them, Sergeant Laughlin continued to observe the vehicle, and in doing so observed a marked lane violation. Sergeant Laughlin then followed the vehicle, and during that pursuit observed a second violation, a turn signal violation. He ultimately was able to stop the vehicle. During that stop, the canine was able to conduct a sniff of the vehicle, and during a probable cause search of the vehicle, the dog alerted during the probable cause search of the vehicle. They found a large amount of marijuana in the vehicle, including the weight of the packaging totaling 237 pounds. After all the testimony, the trial court ultimately did grant the motion to suppress based upon finding a lack of reasonable articulable suspicion to stop the vehicle. First and foremost, the state argues that the trial court erred because certain findings of facts were not supported by competent, credible evidence. The first of which is that the trial court made a finding that Sergeant Laughlin only observed the vehicle's tire to simply touch the right marker. However, Sergeant Laughlin's testimony at no point in time indicated that he simply observed a touching of the tire to the actual right lane marker. Instead, Sergeant Laughlin did testify that he observed the entire tire go over a tire width over the right lane marker for 2 to 3 seconds.
Which was not on the dash cam.
Correct, Your Honor, and that was one of the things that the trial court pointed to, that that particular violation was not on the dash cam. However, Sergeant Laughlin did provide testimony explaining the absence of that from the dash cam video. He did testify that the dash cam video is not activated until the lights and sirens are actually activated, and only goes back 90 seconds. And in a review of that particular video, it's clear that Sergeant Laughlin, where it started, Sergeant Laughlin was actually already on the in the lanes of traffic, therefore making it virtually impossible for the dash cam to actually have captured that initial violation on the dash cam video. Therefore, the state would submit that the competent, credible evidence does not support the finding that the tire merely touched the right lane marker in this case. Further, the state would argue that the trial court erred in failing to make a finding that Sergeant Laughlin did in fact observe the turn signal violation. Again, the trial court pointed to the lack of dash cam video corroborating that particular testimony. However, Sergeant Laughlin did indicate that the dash cam video does lack some quality and clarity, and also has difficulty capturing things that are not directly in front of it. And in review of the video, the vehicle was a little bit a ways away. Furthermore, there was testimony by Sergeant Laughlin that when he did stop the vehicle and engage with the occupants, that he explained the stop was for the turn signal violation. And both he and Ms. Benson testified, in fact, that she apologized for the violation, which, if nothing else, at least is a tacit admission that she did, in fact, commit that particular violation. Therefore, the state would submit that on those two factors, that the trial court's finding of facts were not supported by the competent credible evidence. And moving to the second assignment of error, the state submits that the trial court erred in making a finding that Sergeant Laughlin lacked reasonable articulable suspicion to stop the vehicle in this matter. And a stop is a seizure on the Fourth Amendment, therefore an officer must have reasonable articulable suspicion in order to effectuate the stop. And this standard is actually met if the officer observes a traffic violation, which provides that officer with probable cause to stop the vehicle. And in this, out of this district, State versus Casas actually stated that crossing the road's right lane marker is a traffic violation pursuant to 45-1133, and the Ohio Supreme Court in State versus Mays found that such a observation of that particular statute does provide the officer with probable cause to make the stop. And as previously argued, the state would argue again here that Sergeant Laughlin did indeed have probable cause and reasonable articulable suspicion to stop the vehicle based upon his observation of the marked lane violation, and separately and independently from that, in his observation in observing the turn signal violation as well.
Counsel, what do we do with the fact that the trial court just didn't believe?
What's interesting is that the trial court never stated in its opinion that he did not find Sergeant Laughlin not credible.
Well, the trial court did say these are all credibility determinations, and there's nothing on the dash cam, and one officer's not backing up the other officer, you know, those types of things, so.
And in actually looking at the officers' testimonies, the state does have argument about there being some drastic differences between the two of their testimonies. The trial court pointed out that Trooper Trader did not observe the marked lane violation, but in just looking at the testimony, it would make sense that he wouldn't, because at that point in time, he actually turned to his right to speak to Sergeant Laughlin about what he observed, and therefore taking his attention away from the vehicle at that point. He also indicated, despite what the trial court stated in its decision, that his observations of the reduction in speed as well as their behaviors as it passed in front of him, he would have continued to monitor the vehicle, but because Sergeant Laughlin was there and did observe that additional violation, and he continued to follow it, that obviously would have stopped him from continuing to follow that vehicle as well. So the state does have some contention with that particular statement of the trial court, that there was some large difference between the testimony of the two officers or troopers in this matter. And in addition, the trial court pointed to the Sergeant Laughlin having some sort of ulterior motive in actually stopping the vehicle, pointing to them making stops of vehicles on the turnpike, of out-of-state vehicles, and having large drug seizures, and inferring basically that in this particular case as well, that they had some sort of pretext here. However, in Dayton versus Erickson, the Ohio Supreme Court explicitly found that where an officer does in fact have probable cause to stop the vehicle, any ulterior motive does not make the stop unreasonable under the Fourth Amendment. Therefore, any pretext here, if there was any, which the evidence does not indicate to support that particular statement, would have been wiped away by the fact that Sergeant Laughlin didn't have probable cause to stop the vehicle based upon those two separate infractions that he observed. And therefore, the state, based upon the arguments made here today as well as in our brief, would request that this court, in fact, reverse the decision of the trial court based upon these two separate assignments of error and remand the matter for further proceeding in the trial court.
Thank you, Counsel.
Thank you, Your Honor.
Good morning, Your Honors. Eric Nemechek on behalf of the appellees, Daniel Essad and Kimberly Benson. With me today is Attorney Joseph Delgade. Mr. Delgade has indicated that he would be okay with me handling the 15-minute component of the argument. Please, the court. Addressing the state's arguments made here today and in the brief, they do raise two different issues. However, they're seemingly interrelated in a number of key respects. Basically, the state's first argument about the competent and credible evidence, they appear to be starting from the premise that the police officer's testimony in and of itself constitutes competent, credible evidence of reasonable, articulable suspicion as it relates to a traffic stop. And the primary flaw in that argument is that although an officer's testimony can constitute competent, credible evidence, that finding is not required simply because an officer testifies to certain observations. Rather, the ultimate determination and discretion remains with the trial court to assess the weight of the evidence and make credibility determinations, which is what was done in this case. The contention that the testimony was unrebutted is simply not supported by the record. Sergeant Laughlin's testimony is rebutted by Trooper Trader in a number of key respects. Trooper Trader indicates that he did not see the vehicle come to that dramatic slowdown in speed and react the way that Trooper Laughlin did prior to effectuating the stop, and he did not observe a marked lanes violation. And this is despite the fact that both parties, both Trooper Trader and Sergeant Laughlin, admitted that Trooper Trader would have had a superior vantage point with respect to this violation.
Would that be because his car was on the right and it was an oncoming traffic?
Based upon the positioning of the vehicles, he would have had a superior vantage point, which both Trooper Trader and Sergeant Laughlin
But if they
admitted.
were talking to each other, wouldn't Sergeant Laughlin have been looking at Trader, looking at oncoming traffic coming to us from his right?
I guess theoretically that would be possible, but I believe the testimony at the hearing was such that they both admitted that Trooper Trader would have had a superior vantage point with respect to
Where his
those
vehicle was
observations.
located,
Where his vehicle was located.
but not necessarily where his head was pointed.
Not necessarily where his head was pointed, but again, Your Honor, these arguments that the state has raised about these explanations for why it is that Sergeant Laughlin would have observed something and Trooper Trader might not have, these were all presented to the trial court. So they heard these, it's not new information. Trial court took those under consideration, applied the evidence and testimony that was presented at the hearing, and made a determination that it was insufficient to establish reasonable suspicion. Again, with respect to the dash cam recordings, while it's true that the dash cam did not show either violation, and while that is certainly something that the trial court referenced, there's simply no support for the contention that the trial court relied solely on the lack of corroborating dash cam evidence. In its opinion, the trial court expressly acknowledged the fact that it doesn't require corroboration by dash cam or by another officer in order to find reasonable articulable suspicion. However, it indicated that based upon the totality of the circumstances, the contradictions, and the fact that there wasn't any objective corroboration in dash cam recordings, it made the determination that the state had failed to establish reasonable articulable suspicion in this case.
Excuse me, Counsel, what do you do with a finding of fact, though, that a trial court makes? The trial court says it's all a credibility determination, but yet makes findings of fact that are just not supported by the record.
If the court is referring to the tire issue with respect to...
Or just in general. I mean, obviously in this case, that's what the argument is, that the court made a finding of fact that the tire, that, it just barely touched the white line or whatever, and then evidently the testimony, because we're just now getting the record, so we haven't been able to review it yet, but evidently the testimony was that it was the rear tire went over the line for like 2 to 3 seconds. So the point is, I guess my question is, I know your argument is all a credibility determination, which is up to the trier of fact. But what if the trier of fact makes findings of fact that are not supported by the
Well, in the event that the findings of fact would not be supported on the record, that may serve as a basis for reversal. But I guess my position in this particular case would be the state's entire argument that the findings of fact are not supported are based solely on Sergeant Laughlin's testimony. That testimony is subject to the court's determination as to whether or not it's credible based upon not only the observation of the witness, but also the other testimony and evidence presented at the hearing.
But I guess my point with that is, I understand that, but I guess my point with that is, so if you have testimony that says the tire went across the line and for 2 or 3 seconds, and then somebody else said, no, it just barely touched, then the court can say who's credible and who's not.
Correct.
All right, but what if you have just an officer testifying that it went across the line for 2 to 3 seconds? I think the court could say, I'm rejecting that testimony, and I don't believe you. I don't think the tire did. But can the court come back and say, no, I don't think it went across 2 or 3 seconds. I think it just barely touched. How do you come up with that?
Well, if you look at the testimony in this case with Sergeant Laughlin himself, on direct examination, he testifies about the tire going over the line by a tire's width for 2 to 3 seconds. On cross-examination, though, he testifies explicitly that the tire travels on top of the line for a matter of 2 to 3 seconds. So there's contradictions within his own testimony. So the court's use of verbiage when it comes to the tire touching the line or the tire merely touching the line as opposed to going over, again, we don't have just uncontradicted testimony from even Sergeant Laughlin himself about what the tire did. He testifies on direct that it goes over the line. He testifies on cross-examination that the tire travels on top of the line. And there's case law cited within the appellee's brief indicating that simply traveling on top of the line is not a violation of the marked lanes offense. So I think in this particular instance, we're not dealing with an officer who comes in and testifies that this is what I observed, and there's no other evidence with respect to whether or not that's accurate. You have another officer who testified that he did not observe the marked lanes violation. You have Sergeant Laughlin in his own testimony indicating on direct that it goes over and on cross-examination that it travels on top, and I think that's where you get into then weighing that evidence in light of the other evidence and testimony that's presented at the hearing, and it's not uncontradicted, so I believe that the court is fair and within its right to apply its discretion in determining whether or not that testimony is credible. In getting to the reasonable suspicion argument, the state cites to a number of different bases for contending that the trial court erred in finding that they had failed to establish reasonable articulable suspicion. First, the pretextual motivation. Again, there's nothing in the trial court's opinion to indicate that that served as its basis for granting the motion to suppress. The only reference to it is the fact that the trial court referenced the testimony about the number of stops of out-of-state vehicles and indicated that it raised concerns for the court. But it doesn't say that those concerns form the basis or solely form the basis for the court's determination that there was no reasonable articulable suspicion. The state references the comparison of the case of State v. Davis from this district back in 2015. This court in that case found that Sergeant Laughlin's testimony with regard to the marked lanes violation was sufficient to establish reasonable articulable suspicion, but it doesn't appear that anything in that case that there was significant contradiction of that testimony. And in the opinion in this case, in referencing Davis, the court indicated that Trooper Trader and Sergeant Laughlin had very different observation about the events that led to the initial pursuit. That was at page 5 of the opinion. Thus, the trial court's opinion in this case doesn't contradict the Davis holding that an officer's testimony can provide competent, credible evidence. It simply indicates that in this case that was not established. And in Davis, this court expressly noted that it was required to defer to the trial court's determination that Sergeant Laughlin's testimony was credible. And I would submit that the reverse is also true in this case. Absent some sort of finding that the trial court erred in applying or assessing the evidence in this case, that there should be deference to the trial court's determination as to the lack of credibility of the officer's testimony in support of reasonable articulable suspicion. The state's reference to the behaviors exhibited by Benson and Essad during the traffic stop, again, those post-date in time the basis for reasonable suspicion, so they are not of any significance with respect to this court's determination. And again, the inconsistent testimony of Sergeant Laughlin and Trooper Trader, it's replete throughout the record, it's referenced throughout the trial court's opinion, it's contradicted by the dash cam evidence presented in the case, and as I said before, all of these arguments that the state has and the explanations as to why the dash cam wouldn't have exhibited the offenses and why the officer may not have observed the marked lanes violations. These arguments were presented to the court. The court took them under advisement, presumably, and rendered its decision. So it's not as if the trial court didn't consider it. There's no evidence that the trial court didn't consider or ignored these arguments. It simply found that the greater weight of the evidence failed to establish reasonable articulable suspicion. In essence, if you boil the state's argument down, it comes down to their disagreement with the trial court's determination that Sergeant Laughlin's testimony lacked credibility and ultimately failed to establish reasonable articulable suspicion. If you follow the state's argument to its logical conclusion, then any time an officer comes in and testifies to what they observed, regardless of any other evidence that's presented or any contradictions or the lack of credibility, a trial court's always going to be required to find reasonable suspicion. That would simply divest trial courts of their jurisdiction and their right to make these determinations to render decisions based upon the credibility and the weight of the evidence. And it would basically turn the entire process into a rubber stamp operation where officers would come in and testify to what they observed, and regardless of anything else presented, that would be sufficient in and of itself to establish reasonable suspicion. And I would submit that's not the law in the state of Ohio, and that there's nothing to no legal basis to disturb the trial court's determination in this case. Thank you.
You have just less than 5 minutes.
Thank you. I guess just in first addressing the last point made by County's counsel, the state isn't suggesting that just because an officer comes in that the trial court is automatically required to find that particular officer credible. Here, the state is arguing that the facts pointed to by the trial court in making that determination are not supported by the evidence presented at the hearing in this matter. And as previously argued, the state contends that there are not these huge contradictions between Trader's and Laughlin's testimony, but simply that Trooper Trader stopped observing the vehicle at a certain point when Sergeant Laughlin continued to do so, and therefore was unable to observe the infraction that took place after the vehicle passed in front of them. And in contention with the trial court's finding again that it simply touched, the tire simply touched the right marker. Again, the evidence presented at the hearing did not support such a finding, as there was no evidence at all to that particular finding. And therefore, again, just based upon the previous arguments, as well as the brief, the state would respectfully request that this honorable court reverse the decision of the trial court in this manner.
Thank you.
Thank you, Your Honors.
Thank you to both sides for your arguments presented to the court. The court will take the matter under advisement and issue a written opinion that will be sent to both sides, obviously, as well as release it on our website and this